Would it be odd to have a rule in which the scope of preemption for a tort suit depends upon whether or not there was a breach of a contract as to which he was not a third-party beneficiary?
Yes, that would be very strange in my view.
Suppose that a contractor is building a building and hires a subcontractor and specifies exactly what the subcontractor is to do, and then someone is injured by falling debris, and that person sues the subcontractor. Would it be a complete defense for the subcontractor to say, hey, we weren't negligent, we were doing exactly what the contractor told us to do? Would that be a complete defense?
Not under general tort law principles.
Can the federal government, by regulation, provide a conclusive interpretation of the scope of preemption?
No, they haven't attempted to, but I think they probably would not be able to. That would be left.
When the FTCA provision that's been discussed was adopted, is there anything to indicate that Congress had activities on the battlefield in mind?
There's really no legislative history about that, but the fact that it was adopted shortly after World War II to address combatant activities in time of war would suggest that they had that in mind.
It's been suggested that the federal government has no interest when what the military contractor does is a violation of the contract. Is that simplistic? There can be several different situations. One, there could be a situation where it is absolutely undisputed that there was a material breach of the contract. There could be the situation where the military says there was a breach of the contract. And when something goes wrong, like the bombing on the Wagram base, the military has an interest in trying to exonerate itself. So you could have the situation where the military says there was a breach, the contractor says there wasn't a breach. There could be the situation where the military says there was no breach, the contractor says there was not a breach. So wouldn't the rule that we adopt have to deal with all three of those situations?
I think it would, and I think what's critical here is we are clearly in the situation where there is a disagreement between Fluor and the government about whether there was a breach. The government ultimately made a determination that the best way to continue waging war was to allow the parties to agree to disagree and to move forward and continue to fight the war. But if the decisions of a contractor are going to be subject to state tort suits a decade after the fact, the contractor is going to have to act very differently when an accident happens. The immediate thing that the military needs when there's an accident like this is for soldiers and contractors to work together to make sure there's not a similar attack later that day, the next day. And so you need cooperation. If the contractor knows we could be blamed for this, they're going to want to do their own investigation. They're going to want to collect their own evidence. There will already start to be considerations of, was it the military's fault? Was it our fault? I think one thing, if I can address a statement made before, the district court made clear if this case went forward, Fluor would be able to try the empty chair and say this was entirely the military's fault. You should not hold us liable because the military first made a decision, a foreign policy, that we're going to allow former members of the Taliban onto Bagram because that's a good way to rehabilitate them. The military then decided that Mr. Naib was a former member of the Taliban, not a current member of the Taliban. Fluor didn't know he had any ties to the Taliban. That was entirely the military's judgment that he was former. Mr. Naib, the evidence showed, smuggled explosives onto the base to build the bomb. It was the military's entire responsibility to prevent that from happening. So there's no way this case could go forward. You know, the plaintiffs say if they try the case,
Thank you.
Yeah.